Hi everybody, welcome to this channel. It's my pleasure today to introduce the subject of estate record keeping. This is a rabbit hole that can be very deep and can have many layers that should be unearthed or could be unearthed. But my goal in this is to show how estate planning that focuses solely on the completion of documents is incomplete at best. My name is Griffin Bridgers, and I'm going to tell you more about how you can look to digital assets and analog evidence to create a much stronger and more effective estate plan. Now, as always, I want to remind you that this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. Now, as a preview, there's a lot of personal stories I have around this, but to set the stage, this is not going to be like a lot of my presentations. For one, it's not going to be as technical in nature. This is instead a presentation that is extremely raw. I intend to refine and customize this presentation a little bit more over time to make it a better end product for you, the viewer or listener, and also to allow other people who are interested in this to private label this type of subject matter and maybe even integrate myself or others as a talking head instead of just having slides on the screen. Now, to set the stage, there's a lot of confusion about where professional advisors, whether they're attorneys or non-attorneys, can add value in the estate planning process. And this video, in this series of videos, is going to be about ideas that aren't necessarily new, but can help. My goal is just to maybe simplify this and create the stage to brainstorm those ideas and implement them where appropriate. But as we'll see, the ultimate issue here is that estate planning is a process that never ends. And a lot of people want to treat it as such because it sucks to think about death. Nobody wants to do that. But as we're going to see in this series, the problem may not always be simply thinking about death. It may be challenging your own worldview. But that aside, let's jump into the subject matter of today's discussion. Now, I'm going to redefine estate planning not through some kitschy marketing thing, but more just by the basic definition, because most people define estate planning as just simply being the actual drafting and execution of legally binding documents, followed by the funding of the arrangement of your estate plan through changing asset titles and beneficiary designations in order to be consistent with the documents that you put so much time and attention into, or in some cases that you put very little time and attention into, especially if you just simply went to an attorney and said, just tell me what to do and I'll do it. That's a flawed approach to begin with, but that's a subject for later. Now, I bring that up because there's a ton of homework needed outside of this simple definition and set of documents and even the funding of the documents to make your estate plan effective. And this homework does not end. Once you've finished your will and the ink is dried and you've gotten it back, you can't just simply stick it in a drawer and be done. There's updates needed, at the very least, when your or a client's circumstances change. Now, a lot of this won't be new. And I'm going to bring up digital assets, but hopefully in a completely different fashion than anybody has so far. And this isn't a discussion of the technical elements of planning for digital assets, but more even a broader, more 30,000 foot view of how to approach this. And really the theme here is that everybody has head knowledge that dies with them or goes away if they become incapacitated. The theme here is just simply getting your head knowledge down into an analog written form that can be accessed if something happens to you. So, there's some words I've underlined here, or italicized, and these are going to really be three elements that fall into planning for digital assets. One is you have to look more to the access to those digital assets. Is access available, and how do you go about establishing that access? That's something to be established within your estate planning documents. And to establish access, you also have to define who will have access to those digital assets. And then once you define who has access, in order to give that person access to digital assets, they must know where the digital assets are located. Now, this is homework that you can't pay anybody to do for you. You can't pay an attorney to do this. You can't pay a financial advisor to do this. You have to actually put in the work yourself to do it. Everything else you do is really incidental to solving these issues when it comes to the actual estate planning documents. Without solving this first, as far as I'm concerned, the documents may not be as effective as you think. So this really kind of brings us to the subject of estate record keeping. What is the homework that's assigned to you if you're doing estate planning, or assigned to a client if you're assisting a client with estate planning? In order to have an effective estate planning result, it helps at least to create a master binder of digital and physical assets. Really, you're just organizing what you have. And in a sense, it helps to, instead of thinking about this as a task you have to take on, it's instead helpful to think about it like you're treating your affairs like you're a corporation or a business. So if you were running a business, you would keep books. A business cannot function without bookkeeping. You need to know what assets the business has, how much money comes in, how much goes out, and where those assets are located, and where they fit into the balance sheet. So why wouldn't you create your own bookkeeping system for you personally? So this isn't something that's necessarily driven by the fear of death. This is more something that's driven by the practicality of a lot of things could happen. There could be a fire, there could be a natural disaster, you could just simply be changing professional advisors, but it helps if you just simply write down what your assets are and where they're located and how you access them. That can include digital assets and physical assets. So tying into those themes of access, who has access, and where can we establish access, we really have these elements of where digital assets are located, who can access them, and how to access them. And the same questions hold true for physical assets. Now, security is always an issue. There's a ton of software companies out there that want to integrate your passwords together and integrate your logins together, and that's a rabbit hole we're not going to go down today as to whether those are effective, whether they're secure, and even whether a fiduciary can be allowed to access those types of portals or aggregators. But what I'll leave you with is it's difficult to be more secure than a paper record. But the paper record is only as good as the creator, and you have to keep it updated. So, as far as I'm concerned, with any estate plan, this is where things go wrong. The question from the outset should be, what are your wishes? And this is a question a lot of people just simply won't answer. Because it's scary, it makes you think about death, and nobody has the time or the mental capacity to think about that, because it's sad and scary and has all sorts of other emotions that go along with it. Now, for those of you who are emotionally mature enough to consider this, what I would theorize for you is not so much that it's death that's scary itself, it's more that if you were to write down your wishes, and even your values, or even your legacy, what may be more scary is being forced to possibly confront, now or later, that your own values and worldview and story might be flawed. But I want to leave you with the fact that it may be the fact that they're flawed that makes them effective. So I want to repeat that again. Perhaps the fact that you think your values and worldview could be flawed might be what makes them effective. But I'm getting too woo-woo for this presentation. I just want to plant that seed and jump back to this. But there's a variety of documents and resources out there that you can put together. Things like an ethical will, a letter maybe with instructions for heirs and fiduciaries, simply just explaining things of how you feel about people and what impact they've made on you and what impact you want to make on them. Now, this is where values-based estate planning tends to go wrong, because I view it as being too one-way. I think it helps if you can view this as an equal exchange, that if you're leaving assets to heirs, you're not just telling them what to do and saying, hey, I want you to adopt this value. It helps to also look at the other way. What impact has that heir had on you and your life? And the big question is, could this be done by video? That's another element to consider in a future video, ironically here itself. Now another thing is that we can build another layer into everything we've looked at, an analog record of our digital assets, an analog record of our wishes, and maybe, as with any potential dispute, it helps to create evidence. And really what we're going to do here, with attorney assistance for a reason I'll explain in a minute, is we're going to supplement our entire estate plan with evidence of our intent. Statements of not just what our wishes are, but maybe why we made the decisions we made under our estate planning documents or other areas. Now, this is especially helpful if there are disputes, but it can be an exercise that requires an estate planner, because if you create evidence that's counter to your estate planning documents, you can actually throw gas on the fire. You can make disputes worse instead of making them better. And only you can know the true nature of the disputes. There may be some disputes that you just can't solve with evidence. No matter what, they're going to happen. Some people are just too far gone, and really your only mistake in life might be that you didn't read their minds or kiss their butts or both. And there's really no way to win in that sort of situation. So because of that, establishing your intent may not be a panacea. There may be some disputes that just can't be helped here. But as a starting point, I want to emphasize another reason you need to consult with an estate planning attorney. And another reason why this may not always be effective is because when there is a dispute among heirs or creditors, evidence of your wishes and intent may not even be considered unless there's an ambiguity in your estate planning documents. Now, ambiguity isn't so much that the documents are unclear, but it's more the potential that a provision or term or even a sentence or word in your estate planning documents can be read or interpreted in two or more different or inconsistent ways. So if that ambiguity fuels a dispute, that's where the statement of intent comes into play to help you. Now, that statement of intent could be within the documents themselves, it could be external, but that has its own different benefit and detriment either way you go, so that's why it helps to have an estate planning attorney involved. It's not necessarily the creation of the documents, but integrating all these elements into the documents themselves as well. And I want to mention too that in a dispute maybe with an authority like the IRS, the evidence might help. It may add more value than you think to be able to present that in a tax court if there's a dispute as well. There's some cases recently I'll talk about that really kind of strengthen that element. So the end product here is that an estate planning document, or an effective estate plan, contains 4 distinct elements which can be deployed at a moment's notice or given to an interested party at a moment's notice. One is the documents themselves, more to come on that in terms of what goes into an estate plan at the top of the bell curve. But as I mentioned, there's 3 other elements. An analog record of your digital assets, what, who, and where are the questions you're answering there. Maybe narratives of your wishes and values, etc. Not just that you want heirs to adopt, but more so viewing it as an equal exchange, being able to tell heirs what impact they've made on your life. And also anticipating disputes that could arise, and with the assistance of an attorney and an input of an attorney, making statements of your intent that can supplement all of these elements. And these can be combined or kept separate, but they should be separate and distinct elements that are checked off as you go along. So once you do your estate planning documents themselves, you don't have a complete estate plan, or maybe you don't have a fully effective estate plan. So the question, do you have a will, even if it can be answered yes, is incomplete. Now, more is to come on the order of these and where maybe a good starting point might be, but the overall theme here is just better estate planning, because integrating all these elements can be profoundly impactful. So what I plan to do with this video is expand it more. In the future, I'm going to integrate practice ideas that surround these themes. And there's a 5th element looming in the background which comes in, and that's estate education. In other words, there's a simple question. Do you know what you signed or what you're signing? And a lot of times the answer is no. So this is where somebody like me adds value just as a shameless plug, because all of these videos on this channel have been all about me personally developing not necessarily a business, but an idea around whether it's helpful to have an independent voice, not trying to sell documents or review yours or your client's estate planning documents, to summarize them instead of upsell or change them. And this isn't necessarily a new idea. There's tons of financial institutions and financial advisors who provide this service, but few individuals have really branded themselves as independent resources or consultants in this space. So my goal in all these videos has been either to become one of the first to do so, or even just to simply test the idea. But as to the story of that, it's a story for another time. So thank you for listening to today's presentation. Like I said, this is just the starting point. This may be impactful, it may be not. But either way, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com with the caveat that I cannot give tax or legal advice in response to your questions. But I thank you again for listening today. Be on the lookout for supplemental and follow-up content to this video, and I look forward to seeing you in my future content.